Charged with a crime, but you weren't even there at the time. What's going on? Hi, I'm attorney Paul Whalen from Afford Law. At Afford Law, we practice criminal and family law throughout Massachusetts. Our fees are all based on your income. What that means is that the less you make, the less you pay. So, what we want to do today is talk about what's called a joint venture theory in criminal law in Massachusetts. So, the joint venture theory basically says that you can be charged and convicted of a crime, even if you're not at the scene of the crime and actively participating in the crime as it's being committed. Okay, so let's go back a little bit. So, joint venture means that you must you must work with somebody else towards a criminal end. So, your goal is to commit this crime, say. So, there are a lot of different types of crimes where you could be found as a joint venturer and therefore guilty. Commonly, we see things like possession charges, so possession of drugs or possession of firearms or burglarious instruments, or things such as breaking and entering, and any type of most crimes can be and can involve a joint venture theory. So, in order for you to be convicted of a crime on a joint venture theory, the Commonwealth must prove two things beyond a reasonable doubt. And the first thing is that you knowingly and intentionally participated in the commission of that crime in a meaningful way. And number two, that you shared the same intent as the principal operator of the crime. So let's go back and sort of work through those two elements. So you had to knowingly and intentionally participate in the crime. So that means that if for some reason we can prove that even if you took some action that led to the crime being committed, if you did so without the knowledge or intent to do so, that's a defense to a joint venture theory. As an example, let's say that you let somebody borrow your car. Unbeknownst to you, they go out and rob a liquor store and are charged with whatever it is, armed robbery and so forth. So you could technically and theoretically be charged with the same charges. So charged with armed robbery because you supplied the car that the person used in order to commit the crime. So our job at that point would be to prove to either a judge or a jury that even though you lent your car to that person, you had no knowledge or intent to participate in the crime. It's not like somebody comes up to you and says, "Hey, I'm going to go knock off a liquor store. Can I borrow your car? I'm going to use that, in the commission of this crime." Somebody, let's just say, comes up to you and says, "Can I borrow your car?" And being a nice person, you do so, and then they go out and commit a crime. You should not be held responsible for that crime. Okay, so you have to participate in a meaningful way as well. So it can't be something just slight. So it can't be you give directions to somebody. In our example, so in a non-meaningful way, it could be something like you tell the person how to get to the liquor store. Somebody says, "How do I get to a liquor store? I think I'm going to go rob it," and you give directions to that. That could arguably be that you did not participate in a meaningful way. So you have to have knowledge and intent and participate in a meaningful way, and you must share that intent with the principal operator. So you have to share the intent of robbing the liquor store with the person who actually does rob the liquor store. So let me give you another example from the case law itself as far as joint venture theory goes. So there is a case where there are two individuals and they're both charged with attempted breaking and entering, possession of burglarious tools. I just like the sound of that, burglarious tools. So they're charged with that. And the scenario is this. So the police are going by, it's at night. There are shops, there are businesses that are closed up, locked for the day. And the police officer sees somebody sort of pacing back and forth in front of one of the stores. It seems suspicious at that hour of the day. He stops and confronts the person there. As it turns out, the person has a crowbar and I believe a screwdriver or something else. These are the burglarious tools. So he's going to pry open the door and get into the store and rob it. There's a second person who is also charged because even though they're not at the scene of the arrest and where the crime would have taken place at the storefront, that person is in a car down the road a piece, down the block, acting as a lookout and a getaway driver. So the police arrest that person as well and charge him, and he's convicted of the same charges as the person who was about to break into the store because they have that he's participating in a meaningful way with the knowledge and intent to do so. And he shares that intent with the principal operator. So it's similar to a conspiracy theory. So there are some subtle differences. Conspiracy is actually a separate charge itself. So one of the differences between a joint venture theory and conspiracy is that conspiracy is a crime in and of itself. They call it they call it an inchoate crime. Inchoate just means that it's not completed. So conspiracy is an example. An attempt to commit a crime is an inchoate crime because it has not been completed. So they are similar, but there is a difference. Joint venture is just a theory. It's not a separate crime. So you can't get charged with joint venture, but you can get charged with the underlying charges on the theory of a joint venture. So basically, that's what a joint venture theory is. There are many ways that we can attack the Commonwealth's case against you if you are charged under that theory. I've outlined just a couple of them here. There are many more that we would look into. And of course, the facts are all specific to that particular case. And we would look at the facts of the case to see what other grounds we could have to attack that. So if you're charged with something and you can't even believe that you're charged with it. So sometimes we have clients that come in and say, I get the summons in the mail to appear in court because I'm getting charged with larceny over $1,200 or something along those lines. On such and such a date at a store. I said, I was never there. I was never at that store. I was, miles away with somebody else. I have an alibi, and all that's great. However, if the Commonwealth can prove that you participated in that meaningful way with the knowledge and intent to do so, you could be on the hook for the charges that the same charges that the other person is facing. So it's a very important concept, and we see it quite a bit. Actually, it's very common, and we come up against it all the time. So it's something to keep in mind. As I say, at Afford Law, we do practice criminal law and family law throughout Massachusetts. And our fees are based on a sliding scale, which is based on your income. So the less you make, the less you have to pay for our services. So please feel free to visit us at affordlaw.org and feel free to book a free virtual appointment with me. I would be happy to answer any questions you might have about criminal or family law matters in Massachusetts. Because at Afford Law, we're making justice affordable. Thank you.